The Family Medical Leave Act of 1993 came about to rectify weaknesses in the Pregnancy Discrimination Act of 1979. An eligible employee can get up to 12 weeks of unpaid leave in a 12-month period for the birth or care of a newborn child, the placement of a child in foster care or adoption, to care for a sick parent, child, or spouse, if the employee has a serious health condition, or exigency of a spouse, parent, or child that's active duty. Exigency means urgent need or demand. Military members can get deployed at any time. Fort Bragg recently sent soldiers to Iraq and Afghanistan, and they were given only a 2-week notice. Being that I had a spouse in the Army as well as a parent, I know how hard deployments are. The Family Medical Leave Act makes it possible to spend time with loved ones and handle important business before that person gets deployed. An employee has to work for an employer for at least 12 months and have at least 1,250 hours within that 12-month period. An employee has to have at least 50 employees in a 75-mile radius of the job site for that employee to qualify for the Family Medical Leave Act. Employers must inform all employees about the Family Medical Leave Act if the employer is covered. If an employee fails to follow notice requirements, it may create denial of the exercise of the employee's Family Medical Leave Act's rights. During the time of leave, the organization must pay the health coverage of the employee. If the employee does not return to work, the employer may request to be reimbursed. If it's last minute, the employer must be notified as soon as possible. Your employer must offer you a job, but it might not be the same job before leave. The law does not require your employer to give you your old job back. Recently, in September, the 7th Circuit Court of Appeals ruled that an employer does not have to grant more leave as a reasonable accommodation. This is not the final say. If the case is appealed, it can be heard by the U.S. Supreme Court. If your child is over 18, you may still be covered by the Family Medical Leave Act if your child is incapable of self-care. If an in-law gets sick, you are not covered. It has to be your own parents. An employee may cut your leave short if you do not provide the proper medical proof of your condition. Your employer cannot deny your request for leave as long as you haven't exhausted all of your leave already and follow all guidelines. Employers are not allowed to retaliate against employees. There have been many lawsuits against companies for violating employees' Family Medical Leave Act rights. Some employees win and some lose. One tip is to make sure you stop by your Human Resources Department and fill out any necessary forms. If you feel as if your rights have been violated, you may contact the Department of Labor.